First we have a discussion on the important area of Bharatiya Nagrik Suraksha Sanhita 2023. Page is information to the police and their powers to investigate. This head is and comprises section from 173 to 193. What it contains? There are total 8 heads. The first one is cumulatively the provisions with regard to information to the police and their powers to investigate from section 173 to 193. Within these provisions, the first head is the information in cognizable cases governed by section 173. The first information report and information as to non-cognizable cases and investigation of such cases governed by section 174. Then general provisions relating to investigation from section 175 to 182. Then recording of confessions and statement governed by section 183. Then medical examination of victims of rape governed by section 184. Search by police officers section 185 and 186. And then a question arises when procedure when investigation cannot be completed within a span of 24 hours. When MCR, when PCR is governed by section 187. And then miscellaneous provisions from section 188 to 192 and concluding provision 193 deals with report of the police officer on completion of investigation. What we use the term charge sheet. So one by one these heads we will discuss. So chapter 13 lays down how information regarding offences must be provided to the police and how the police should record and process such information. So everyone should know when what kind of offence is committed, accordingly how the criminal law come in motion. So this is governed and how the law function, work out, operate the control, how investigation process is carried out, what it contains with regard to the investigation process, what are the stages, when investigation commences and when, how long it go and when it concluded. So these provisions replace chapter 12 of the CRPC, forming chapter 13 of BNSS, covering procedure from police receipt of information to the closure. These provisions describes the various things, particularly the rights of the informant, right of the victim, including a situation when sexual offense is committed, then how to respond with the victim, what are the special safeguards to the victim of offense of rape and attempt to rape, even person of being disabled mentally, physically, minor, old age, sick. So whether law is equal for all, does it mean? No. Keeping in mind revealed source, sorts of circumstance, law is so sympathetic. So that we are looking how the provisions are responding to the situation. This chapter 13 elaborate the circumstances under which the police can conduct preliminary inquiry or begin formal investigation. It grants police power to the police to investigate including to collect the evidence, visit the place, search the place, collect the data. So conducting searches, pursuing and collecting the data is concerned, what kind of procedure is to be followed? It's concerned. The provisions are prescribed. The significance of this chapter is, in compare with the CRPC, the timeline is prescribed. Whenever police comes to investigate, so to create a check and balance, at one side the power of the police and other side responsibilities of the police, to ensure fair and efficient investigation process. This chapter also provides remedies if the police officer refuses to register the offence, register the information which is given by the informant. What kind of remedy is available to the informant? Enabling escalation to senior officers or to even magistrate, how it is to be reached, what kind of procedure is to be followed, what are the steps, when and when not. Overall, these sections create a structured, accountable, a victim-centric. The earlier approach was accused-centric, but it is shifted from accused to victim-centric. So the legal framework we are going to discuss, how the offences, how the informant report, how the information is given to the police, information at first hand. What does it mean FIR? How FIR is, who maintain, how maintain, what kind of procedure is followed, what is the use, what is significance, how long, whether it is part and parcel of evidence or something else. So many things we need to investigate, we need to discuss. So first of all, we are going to switch on in overall discussion on section, particularly information to the police and their powers to investigate. So section 173 deals with information about cognizable offence. 173 section deals with information about the cognizable offence and how this information may be given to the police, by what manner, orally, electronically, and must be recorded and signed by the informant. Section 174 deals with information about non-cognizable offences. And same is also recorded, but investigation requires prior permission of the magistrate. But so far as cognizable offence is concerned, there is no need of prior permission of the magistrate to start the investigation. Section 175 deals with police officers have full authority to investigate the cognizable cases without needing court's order. Section 176 deals with investigation must follow prescribed procedure, including visiting the scene spot where the offence is committed. They are collecting the evidence, examining the witnesses. Section 177 deals with police must submit investigation report, including electronically, in a format prescribed by the state government. Section 178 to 1 178 to 182 deals with and regulate the preliminary inquiry, witness attendance, witnesses examination, statements. The responsibility is on the shoulder not to indulge with certain practices, particularly inducement, threat, promise. Section 183 to 185 deals and provides procedure for recording confession before the magistrate. The victim, the medical examination, police searches. 187, when investigation cannot be completed within a span of 24 hours. So, what does it mean police custody? What does it mean magisterial custody? Section 190 to 192 defines the when cases must be sent to magistrate, rights of the complainant, rights of the witnesses, and the diary which maintained by the police officer at the station, which concern the provision is R. Then concluding provision 193. This is called police report. How this report is. So after completion of the investigation, which is carried out in preceding provisions, police must file a compiled the final report without a delay, as timeline prescribed accordingly, including details of evidence, arrest, regarding records, medical reports, panchnamas, inquest reports. If certain offence must be, its concern timeline, guideline is given accordingly. The whole thing is to be submitted to the magistrate. The purpose is to take the cognizance of the offence. For your information, there are certain ways through magistrate can take the cognizance of the offence. One is through report submitted by the police. Accordingly, the magistrate take cognizance. Even otherwise than on police report, magistrate can take cognizance. Even suo motu can be taken. So there are certain ways through which magistrate take the cognizance of the offence. So now we are discussing here, right from the moment when the police came to know the particular kind of offence is committed, then how criminal law is come in motion, what kind of responsibilities are on the shoulder of the police, what kind of power they can exercise. If the offence is of such character and that character, it means if it is cognizable then what, and if it is non-cognizable then what. And how the things developed, investigation process. The part of investigation is effecting the arrest, part of investigation is searching, part of investigation is the seizure, part of investigation is the recording the statements of the persons, collecting the evidence, taking the medical examination, conducting with the assistance of the medical department, and if voluminous work then compiled and need use the term charge sheet, the police report, how it is to be submitted, and after submission of the charge sheet, then next course of action in accordance with the further chapters, the things will take its own turn. So now we are proceeding towards the important provision of the chapter 13 is section 173, wherein the term FIR, the offence serious in a nature, cognizable offence is concerned. The information in cognizable cases is concerned, section 173 is in use. This section lays down entire legal procedure for registering an FIR, the first information report when the information relates to cognizable offense. What is cognizable offense? Accordingly, the schedule first prescribes the kind of offenses mentioned in the table as cognizable, where without permission of the magistrate, police can take investigate the offence, and as part of investigation, they can effect the arrest. There is no need to obtain the permission from the magistrate because the severity of the offence. It significantly modernizes the process by permitting this provision. Now BNSS allows the information is to be obtained and is to be received by electronic communication for strengthening the safeguards of the woman, even simplifying the reporting process is the kind of change what we feel. So inculcation of electronic mechanism for the sake of giving more suiting and accessible atmosphere, the 173 provision is enabled. This record information is what is commonly called as FIR, first information report. Information at the first instance received by police from the informant is to be reduced in a booklet. The cumulatively is known as first information report. It contains many things. What does it mean exactly then FIR? FIR is an official written record. Official written record of information given to the police officer relating to the commission of the cognizable offence, prepared in the manner as prescribed under section 173 by the state government. The state government is empowered under section 173 to develop your own mechanism. So in Maharashtra, throughout Maharashtra, unique mechanism is developed, the register, wherein the details of the informant about the cognizable offences is concerned, the information is noted, is to be recorded. This is official record. This is the written, formal. Information about the cognizable offence may be given either orally or electronically, whatever the kind of the person being informant is. If he is illiterate, he can give orally. If he is well learned, he can give even electronically. If oral information is given, the police must reduce it into writing, read it back, and get it informant's signature, whatever the written. If the information is given electronically, it must be taken on the record and must be signed by a person being sender. He has to appear before the police within the span of 3 days, has to take out the print and he has to sign it. Then it becomes valid FIR. The recorded information must be entered into the police station, the so-called register, in the format as prescribed by the state government. FIR can be lodged irrespective of where the offence is occurred. Offence is committed somewhere, the informant can give the information from anywhere in India. This is called as zero FIR. This term is used. If the informant is a woman, the victim of the sexual offences, her information must be recorded by the woman police officer. What is mode of giving information? Information about cognizable offence may be given in two ways. One, orally, other by electronic communication. Orally, if the information is given orally, the officer in charge must reduce it into writing, read it back, and to be given to the informant for his signature. This written record become FIR. Electronically, the BNSS merely allow FIR to be given via electronic means, by mail, if there is a window created on the portal, even if there is app developed, etc. Mode can be through which, through the medium, you can fill the information and share. If such mode is used, the informant must, within the span of 3 days, he has to appear before the police and he has to sign the things. This reform makes the emergency reporting quicker and more accessible. Appearing before the police sometimes may cause hardship. If there is a delay in filing the FIR, the consequence ensues badly, and the result in the benefit of doubt, sometimes accused may get. There are numerous inferences can be drawn up if there is a delay in filing the or in registering the offence. Whether it is mandatory to entry in the police register at the police station. If such question is asked, the answer is yes, it is mandatory, it is not recommended, it is not optional. Unless you enter the information in the format as prescribed by the state government, your offence never at all be registered. If it is not registered, then the criminal law is not coming in motion. Every such information, it is what is expected to the state government, whatever the data prescribed, whether written or electronic, must be entered in the register, kept at the police station. If the informant in the format prescribed by the state government. The purpose is to ensure the transparency, accountability, and throughout the state of Maharashtra, process to register the offence should be one and the same. Police station to police station. What about offences if victim is woman of sexual offences? Is there any special treatment? The answer is yes. The cause is to safeguard and strengthen the sensitivity and comfort for victim of the crime scene. Particularly offences, offense of rape, attempt to rape. If the information is given by a woman victim of listed offences under the BNS as a sexual offences, the information must be recorded by a woman police officer. There is no may, there is shall. Or by a woman so-called officer of the so-called rank. Is there any territorial relevance? No. There is no territorial relevance. Where offence is committed, disregard of it, wherever you are, whichever may be the police station throughout India, where offence is committed, no matter where you are, which police station is nearer to you, accessible to you, there you can go and can inform the police. A police has to receive the information and accordingly the criminal law come in motion. There is no need that you supposed to go to before the so-called police station. No. This is term is used zero FIR. So whether registering offence is mandatory? Yes, it is mandatory. There is no option. It is not optional. It is not discretionary. It won't work. information clearly discloses a cognizable offence, the police must register the FIR. The reason, let the police become accountable. If once realize that offence is by nature is cognizable, the obligation is created. So immediate intimation, immediate initiation of investigation is required whenever cognizable offences are committed, and therefore there won't be no refusal on the part of police once offence is registered. So check and balance is created. This principle continues from earlier jurisprudence, but it is strengthened through explicit procedural clarity. What is the nature of FIR? FIR is the first step in criminal justice process under the Bharatiya Nagrik Suraksha Sanhita. It is a written document prescribed by the police when they receive information about the commission of a cognizable offence. It is not evidence. FIR is not a piece of evidence, but it sets the foundation for investigation process. FIR must be recorded promptly, signed by the informant, and a copy of the so-called FIR is to be given free of cost to the informant. This is the law. What is the use? What is the significance? What is the importance of FIR? Because of FIR, investigation is initiated. Without FIR, cognizable offence is concerned, there won't be initiation of investigation. As soon as information is reduced in writing, in the book prescribed by the state government, soon the investigation process are initiated or commenced. So FIR empowers the police to start investigation without prior approval from the magistrate. There is no need to obtain, there is no to process the process to obtain the permission from the magistrate. If we are processing the process for obtaining the permission from the magistrate, sometimes the so-called person who has given the scene, he may run away, he may do all the mischief, he may create hindrances, hampering and tampering of the evidence sometimes may cause. Therefore, without wasting of time, as soon as offence is registered, the police has to initiate the process to investigate, and resulting, the first step is to effect the arrest. Even official record of crime, FIR is official record of, this is formal record. It serves as the earliest record of the alleged offence, capturing details like time, place, nature of crime, identity of accused, if it is known. Because of FIR, there is possibility to avoid manipulation. There won't be preconceived notion of mind. You cannot set the mindset. Whatever natural, it will come out. If it, at early stage, if it is given. So this is the importance. So since FIR is recorded at the earliest point, it reduces chances of fabrication, alteration of fact, at one's own whim. No. The FIR plays vital role with regard to the judicial oversight. FIR is sent to the magistrate, the copy. The purpose is to ensure transparency, creates accountability. The so-called police machinery become accountable to initiate the process. While arrest is delayed, the police are answerable. They must show the sufficient cause why arrest is effected in late in time. If once offence is registered, investigation commences, arrest is the part of the investigation. FIR, the importance lies with rights of informant. Under BNSS, the informant has the right to receive a copy of FIR free of cost. Track the process of investigation. The informant can ask to the investigation officer, this is the timeline prescribed by criminal law. Whether that stage is over, what is the stage, what is the development, he can track time and again. This is the importance lies with the victim and informant. It is foundation for the trial. The whole trial process is based on this report, first information report. Though the FIR is not a, what I mean to say, a piece of evidence, substantive piece of evidence, but FIR plays a vital role to the court to understand the sequence of event right from the beginning and corroborate the things, whatever witnesses depose the fact before the court during the course of examination at the time of trial, the court can corroborate it to know the chain of crime. The question sometimes may come, who can file FIR? Generally, what we think, the victim. In murder case, who is the victim? So there are many circumstances to cover up all kind of situation. The BNSS has developed eventually and opened a window, a victim of the crime. The person victim directly affected because of the violence, because of the offense. Even the person being eyewitness, in his presence, the offense is committed. A person, anyone who saw, what we use the term eyewitness. Eyewitness means in his presence, he is the person at the place. Even there are certain offenses wherein the relatives, even friends of the victim, even any person being citizen of this country can, whenever he never become a silent spectator, he too is a competent person to inform the commission of the cognizable offense. Even the police officers on duty, they too are empowered under the section 173 to register the offense, to inform the police officer and make them understand the seriousness of the offense and then file FIR. This is section 173. Now we are proceeding towards section 174. 174 pertaining to the an offense of less serious in nature, non-cognizable offense, NC, governed by section 174. What is caption? Information as to non-cognizable cases and investigation of such cases. Section 174. Section 174 deals with how the police must handle non-cognizable offenses. Offenses in which police cannot arrest the accused without permission of the magistrate, without warrant from the magistrate, and even cannot investigate the offense without permission of the magistrate. So arresting a person or investigating an offense is concerned unless magistrate permit. No arrest, no investigation. The reason is, for such and such offenses, the general public shall not be dragged. Let the judicial scrutiny, the judiciary has to look. If judiciary find the severity, the judiciary will allow, then you have to effect the arrest, you have to bring the accused before the magistrate, you have to investigate the things. Unless the magistrate permit, you cannot. This provision clarifies the process of recording information and the legal limit information is received by the police relating to non-cognizable offence, recording of such offence is mandatory. The police officer must record the information in the format prescribed by the state government. This is similar to FIR, but it does not become a formal FIR. How the FIR is under section 173. There is difference. FIR is merely for cognizable offences under section 173. So far as non-cognizable offence is concerned, whatever the record of non-cognizable offence is recorded, police cannot come in motion immediately unless things are processed. The police cannot begin investigation on their own initiative. Instead, police officer must enter the information at the station, issue a referral to the informant and directing them go to magistrate. What is the requirement for obtaining the permission to investigate the offence or to effect the arrest? For a non-cognizable offence, the police must obtain an order from the magistrate before starting any investigation. This maintains the judicial oversight, judicial scrutiny. If judiciary think, magistrate feel the arrest is required, then investigation is required, then otherwise any layman can be dragged and brought before the magistrate. Jail become village and village become jail. So to avoid such unnecessarily, person shall not be suppressed, repressed, oppressed, and there shall not be police atrocity. There cannot be any space for arbitrary act on the part of the police. Therefore, magisterial scrutiny is required. If nature of offence is such where arrest is required, magistrate issue the warrant. Investigation is required, magistrate issue the permission. So unless permit, no investigation. Unless warrant, no arrest. So far as non-cognizable offence is concerned. Power of police after the magisterial order. Once the magistrate authorizes investigation, police can examine witness, collect evidence, conduct inquiry, just as cognizable offence. If permission is given for investigation, then you have to investigate. You cannot effect the arrest. During investigation, if it appears to the police, someone needs to be arrested. Unless warrant is received from the magistrate, arrest cannot be effected in non-cognizable cases. This is the check and balance created under the BNSS. When there is a case of such a character, partly non-cognizable and partly cognizable, the BNSS read the offence is cognizable. So if the information discloses that a non-cognizable offence and a closely connected cognizable offence is perceived, the police may investigate the offence without magisterial permission, because the cognizable part gives them full authority. We cannot demarcate this part is non-cognizable and this part is cognizable. For committing a murder or rape, entering into from this side and that side is a trespass. Insulting also an offence. Touching to the body is a simple hurt. Then grievous hurt. Then things go high. So you cannot sever the part. You cannot sever the status of the commission of crime. You cannot sever the preparation from attempt and attempt from the commission. So this is the chain of the crime. So there cannot be severance that one part is non-cognizable and another part is cognizable. So under this circumstance, once offence is perceived as cognizable, though at the beginning it was non-cognizable, but in later in time it became cognizable. The BNSS read as cognizable, and once offence is cognizable, police has full authority to investigate the offence and effect the arrest. Section 175 to 182, general provisions relating to investigation. Once offence of cognizable, offence of non-cognizable. Both kind of offences are once registered. Then we are coming to the phase of cognizable offence is concerned. What kind of procedure is followed for the initiation of investigation and how investigation is developed. Any officer in charge of a police station may investigate any cognizable offence that falls within the jurisdiction of the competent court. Within the jurisdiction of competent court, any police officer can investigate the offence. That means there is no need that particular officer has to investigate. Generally, the in charge of the police station who appoint someone, his officer, to investigate the cognizable offence. But there are certain kind of offence even other than the police station, the whosoever officers are, the state government can appoint as a special officer. So there is no bar. Any police officer can investigate the offence when committed within the territorial limit of the particular court or magisterial court. So the superintendent of police may direct deputy superintendent of police to investigate the so-called serious offence. And an investigation cannot be challenged merely because a particular offence officer is not capable. No one has such authority to raise the objection, neither victim and nor accused. None of one has any right under the BNSS to raise the objection about the capability of the investigation officer. No, it is the domain of the state. The state has authority they only decide who has to investigate the offence. It is not the matter of right of anyone. Accused cannot say instead of him some other officer is to be deputed to investigate the offence which is charged against. No, you don't have authority. You cannot say. Who has to investigate? It has to be decided by the state. So the magisterial oversight. A magistrate under section 210 of BNSS may order investigation after considering an affidavit and conducting necessary inquiry. The eyes of the magistrate is so different than the investigation officer. At any page, at any line, they can realize the kind of offence. At the initial stage, it appeared that this is non-cognizable. Referral is made, and accordingly the victim appeared. And then the magistrate realized, oh, this is not non-cognizable, this is cognizable offence. The magistrate is empowered to investigate the offence, bring the record, submit the report, and then offence of non-cognizable is registered, and accordingly the things will take its own turn. So cases involving the public servant, the magistrate may order investigation only after receiving a report from the superior officer and considering the public servant's explanation. The superior officer has to record the offence. Then the below rank officer is concerned, the necessary action is initiated. Section 176, procedure for investigation, initiation. When a police officer suspects an offence under section 175, he must send a report to the magistrate. Proceed personally or deputy a qualified subordinate to spot the investigation. As soon as offence is registered, send the report to the magistrate and come to motion and start the investigation. It includes proceed to visit the spot. No need to visit the spot when the accused name and the case is not serious. Well-known person is, no need. If offence is non-serious, no. Officer find no sufficient ground to investigate. Evidence is deficient, no evidence is exist. Officer must record reason in his report. Special protection is given under BNSS if the informant is victim. There is a category of offences prescribed under BNS and named as sexual offences. Whenever the chapter of sexual offences never called before the police station, in the police station. Wherever the victim is, there police officer has to go at the victim's residence, the place of her choice. By a woman police officer merely, the statement is to be recorded in presence of the family or the so-called guardian or even of the social workers. For offences punishable with 7 years or more, a forensic expert team must visit the scene in terms of the kind of offence committed, collect the evidence. Videography is must. Before touching to any scene, any part of the scene, first phase is videograph. Whenever there is a case of suicidal death by hanging, by poisoning, no one can touch the body. By first the videography, then the remaining things work out. Then inquest report, then panchnama, then recovery, then remaining. So each part is to be recorded so that you can relook the things. Section 177 with regard to report how submitted. Report prepared under section 176 must be submitted through a superior police officer or as per the state government, whatever direct accordingly necessary changes is to be made, and report is submitted to the through the in terms of the superior officer's direction under their dictate, send it to the magistrate. Section 178, power to hold investigation or preliminary inquiry. What is the magisterial power in this regard? Upon receiving a report under section 173, so 176, the magistrate may direct further investigation, proceed immediately with the case, depute a subordinate magistrate to hold preliminary inquiry. The purpose is to ensure timely judicial oversight, allow swift action in urgent matters, provide flexibility to filter out weak cases only. It means that once a report is submitted to the magistrate, magistrate has to look if there is a referral, and if it appears to the magistrate this is serious offence, the magistrate can direct to investigate and submit the report to take the cognizance. Accordingly, offence is investigated and whole report will come in later in time. So if offence is committed so serious and police made it non-cognizable, does it mean judiciary goes silent spectator? No. Let the judiciary understand the seriousness. Therefore, the magistrate before whom the reporting needs to be submitted in advance. So, the magistrate should know who is coming next day, who will be appear after arrest. Advance knowledge the judiciary should have. Even the offence shown sometime, whatever reduced in writing, unknowingly, the so-called police submit the report, keeping in mind this is the non-cognizable, but in the eyes of magistrate it may be a cognizable. So to take the serious of the knowing the seriousness, the magistrate can take the cognizance. Section 179, police officers' powers to require attendance of the witness. As a matter of power of the police, whenever offence of cognizable in nature, once it is registered, the offence is filed in FIR, copy is given free of cost to the victim, a copy is given, report is submitted to the magistrate, one copy is in the hand of investigation officer, one copy as official record. As soon as the copy is received by the investigation officer, he has to commence. He has to start can notice to appear for the examination. But there is a restriction on calling someone at a police station. That does not mean he can call anyone. No. Except the so-called person he can call. Who? Woman cannot. Person below 15 years cannot. Person over 60 years cannot. Person being mentally and physically ill. Even person with acute illness cannot walk. He cannot compel to walk. Such a person must be examined at the place of their residence, where investigation officer has to proceed towards their place of residence, and there he has to examine and he has to take the record. Witnesses outside jurisdiction cannot be compelled. There are very what I mean to say derogatory situation we may find. Once offense is committed in presence of us, doesn't mean we shall not go to Kashmir. We cannot go here and there. No. Your movement cannot be restricted because you are eyewitness. You can go anywhere. You cannot compel. You cannot restrain. Mister, for 15 days you cannot go anywhere, here and there. Police has no authority to restrain. Section 180 provides for examination of witness by police. How? I may examine any person appointed with the fact of the case. Witness must answer the questions put forth by police investigation officer. Accordingly, trustworthy answer should be given. It is binding force. You cannot make any fabricated or what I mean to say. You cannot hide the things. Whatever you knows is an offensive act. So statement must be recorded. Verbatim in written, it means what? Verbatim means?
Verbally provided.
No.
As our words.
If it is, if question is asked, did you saw this scene? If yes, if he said yes, then you write yes. You cannot write no. Got it? As such, whatever, if sometimes vulgar word is used, being tribal family, there is a difference in literate and illiterate. There may be a chance of the using the particular phrase for a particular term thing. Sometimes for their community, the particular word is used. So whatever community word, whatever tribal community is, whatever the segment of the society wherein the particular word is used for particular kind of practice, as such it is to be. Shivi, you write. No signature, no thumb impression of the witness may be taken on the statement. Special rules for sexual offences. Statement must be recorded by woman police officer. Audio, video, visual can be used. Statement to police and use thereof. What is the use? Statement made to the police shall not be signed by the person making them. And even such statement cannot be used as piece of evidence at the time of trial. But can be used for contradicting the prosecution witness whenever trial, during the course of trial. They may be used in a re-examination only to explain the matters from cross-examination. But there is exception. Does not apply to statement made under section 26 clause A of the Bharatiya Sakshya Adhiniyam. Omission in a witness's earlier police statement may amount to contradiction depending on the context. Section 182 provides for no inducement. This is the obligation on the part of the police. No inducement be offered. Though you are police officer, though you are investigation officer, you cannot compel. You cannot offer. In accordance with the dictate of police officer, statement cannot be made. The statement should be voluntarious. Whatever seen, whatever knows, as such he must state. What kind of statement one should be given, you cannot create the force pressure, and therefore the here is the accountability is created. approaches on the part of the police, the court will record it if it appear. If it is appear to the police, the trial court during course of trial or during course of inquiry, if it appear, the statement is recorded and through the inducement or through the promise or through the such kind of practices. The court will record. It should be voluntary. Police cannot prevent any person from making any voluntary statement during investigation. Whatever he knows, he has to put forth, and accordingly is to be reduced in writing. However, this does not override section 183 clause 4 concerning recording the confession. That is different part. Now we are proceeding section 183, recording of confession and statement. Confession is always recorded before the magistrate. Even statement can be. Confession by accused, co-accused. Even witnesses can, even victim can make the statement before the magistrate. Statement is not merely given before the police. Statement can be given even before the magistrate under certain. So section 183 BNSS lays down the complete legal procedure, safeguards and requirement for recording confessions and statement before the magistrate. During the course of investigation is going on, but because the offence is registered at the police station, investigation officer is investigating, and meanwhile even he can be brought before the magistrate for confessing the offence. Even victim of the offence of rape can be brought before the magistrate to make the statement. So confession and 183 and from BNSS 164 for statement before the police, but here 183 before the magistrate as confession as statement. Doni, witness, victim, statement, co-accused, confession. Authority to record confession or statement by the magistrate. Any magistrate, that does not mean the magistrate who has competency to or jurisdiction to take the cognizance of office. No, any magistrate can record the confession, can record the statement. Any magistrate of the district where the offence has been registered may record a confession or statement. This power exists if the magistrate does not have jurisdiction over the actual case. Neither he conduct inquiry nor he can conduct the trial. Even then he can record the confession or statement, keeping in mind the situation, so called security. Sometimes it may be useless formality. Therefore, better to, as early as possible, statement is to be recorded by the confession is to be recorded by the co-accused. So recording of
पोस्टमॉर्टम पण आता डेड बॉडीचं एक्झामिनेशन मेडिकल एक्झामिनेशन आता पोस्टमॉर्टम पण व्हिडिओ शूटिंग करून
आता तो डिप्लॉयमेंट आता आले BNSS. If suppose body suicidal death, hanging, you have to videograph the scene. You cannot touch the body.
इवन पोस्टमॉर्टम करत असताना
Yes. Shall I conclude? So recording of confession and statement. So we will stay here.